for Tobago, ensure that Tobagonians have more control over the public service.
Tobago, this is my land, the greatest little island.
Unleash the power of truth with Street 919 FM. Dive into the raw, unfiltered world of politics with our cutting-edge commentary and fearless analysis. We don't shy away from the tough issues. We confront them head on. The Street 919 FM, the #1 election station.
Run by the Privy Council a few days ago. I would like to pay tribute to Madam Justice Marcia A. Caesar for having the courage and the determination to make an important stand for the independence of the judiciary and the security of tenure of judges. That stand has produced landmark decisions of both the Court of Appeal and the Judicial Committee of the Privy Council, which would create a precedent throughout the Commonwealth to enforce the principle of the independence of the judiciary and the security of tenure of judges. I would also like to pay tribute to the legal team which assisted in having this battle fought with success. The battle traveled from the High Court to the Court of Appeal and then to the Privy Council in London. The public probably does not realize that this case went to the Privy Council twice. While the claim was pending, the claimant's attorneys at law made a request for the cross-examination of the witnesses of the JLSC, and the JLSC refused. That battle was fought in the High Court. The High Court refused our application to cross-examine those witnesses. We succeeded in the Court of Appeal, which ordered the cross-examination of the witnesses of the JLSC. The JLSC appealed to the Privy Council, and the Privy Council dismissed that appeal, ordering that the witnesses could be subjected to cross-examination. That cross-examination occurred during the time we had the COVID pandemic, so there was a virtual hearing. The members of the legal team in London were Mr. Peter Knox, King's Counsel, Mr. Robert Strang, and Mr. Richard Langley. The members of the legal team I led in Trinidad are Mr. Ronnie Bissessa, Senior Counsel, Ms. Vijaya Maharaj, Ms. Nyala Badal, and Mr. Varun Gopal Gosain. They are all here with the exception of Mr. Gosain, who is on a short holiday. Let me tell you something about the trial. As mentioned to you, the trial was a virtual hearing during the COVID pandemic. The Chief Justice was cross-examined, and some of the other witnesses of the JLSC were also cross-examined, including the Administrative Secretary to the Chief Justice, Ms. Shirlan Pierre Desagne. She is now a Master of the High Court, and the Registrar of the Supreme Court, Mrs. Jade Rodriguez. I would like to congratulate and pay tribute to Ms. Shirlan Pierre, because as you would see from my statement, she played a very important part and was brave enough, and she did the right thing in giving correct evidence. The claimant and her witnesses did not raise any objection to be cross-examined, but the JLSC decided only to cross-examine the claimant. The other witnesses were the husband of the claimant, Ricky Matthew Caesar, a magistrate, Clevan Raphael, the priest of the claimant, Father Godfrey Stout. They all gave affidavits, and they were prepared to be cross-examined, but the JLSC decided not to cross-examine them. There's a principle in law that by the JLSC not cross-examining and challenging those witnesses' evidence, the evidence of those witnesses remained unchallenged for the judge or the Court of Appeal to assess. The Court of Appeal victory. Justice David Harris had dismissed the claim of the claimant in the ruling he gave in the High Court. The claimant filed an appeal to the Court of Appeal, and the Court of Appeal unanimously allowed the appeal of the claimant. The Court of Appeal comprised Justice of Appeal Mendonça, Justice of Appeal Nolan Barrow, and Justice of Appeal Alice York Sohan. The Court of Appeal made declarations and orders The Court of Appeal declared that the decision of the JLSC to force the resignation of the judge was unlawful and made an order for her to be compensated for the violation of her public law rights and the protection of the law guaranteed to her in Section 4B of the Constitution. This was an important decision in which the highest court in Trinidad and Tobago decided that the decisions and actions of the JLSC were unlawful in forcing the claimant to resign as a judge. The decision of the Court of Appeal made it clear that the Constitution provided a special and exclusive procedure for the removal of a judge, and the procedure must be used to remove a judge, and that it was unlawful for the JLSC to remove the judge from office by forcing her to resign. The Privy Council endorsed the orders made by the Court of Appeal, declaring that the decisions of the JLSC were unconstitutional, and the order for the judge to receive compensation also endorsed that order. I just want to give you an overview before I go into the depth. What I want to do today is to explain to you, and by extension the public, the facts of this case, what was decided. There were some matters that never came out in the public. They would come out today, and therefore I want the public to understand this case. The reason that I want the public to understand this case is that this is important. This is a case in which the body which is charged by the Constitution to appoint judges and who play a very important role in the discipline of judges were found by both the Court of Appeal and the Privy Council to have violated the Constitution to remove a judge from office. And to remove a judge not by making a mistake, but by removing the judge by an orchestrated plan to make that judge resign within hours on the 27th of April. Notwithstanding that the Constitution provides in clear and unambiguous terms that Section 137 of the Constitution sets out an exclusive procedure for the JLSC to follow to remove a judge from office, the JLSC, in removing the claimant as a judge from office, decided not to follow that procedure. The JLSC decided to remove the claimant as a judge by employing the means to force her to resign as a judge. This was a clear misuse and abuse of power by the JLSC and a naked violation of the constitutional rights of the claimant. The JLSC is a body established by the Constitution of the Republic of Trinidad and Tobago to be responsible for the appointment of judicial officers, including judges of the High Court and the Court of Appeal. The JLSC also plays an important role in the discipline of judges, both in the High Court and the Court of Appeal. It must be of great and grave concern to right-thinking members of the public for the highest court in Trinidad and Tobago and the final court, the Privy Council, to hold that this body, which is responsible for the appointment of judges and plays an important part in the discipline of judges, nakedly violated the Constitution of the country to remove a judge from office, especially where that removal took place within a few hours of the 27th of April 2017. On the face of these facts, it must have been obvious to any right-thinking person that that was wrong. It was not only wrong, but it was as if the Constitution of the Republic was being overthrown by the JLSC. The foundation of law and justice in Trinidad and Tobago is an independent judiciary and for judges to have security of tenure. That is the reason why the Constitution provides an exclusive procedure to be followed to remove a judge. In my view, based on the decisions of the Court of Appeals and the Privy Council, the JLSC, with the eyes of its members wide open, disregarded the clear and unambiguous words of Section 137 of the Constitution, the effect of those words and the spirit of that section of the Constitution of Trinidad and Tobago. in order to give you at this stage a taste of some of the things that the Privy Council said about the impugned decision of the Judicial and Legal Service Commission, I will just quote a few. Just about 4. There are many more, just about 4. The option given by the JLSC to the claimant, and this is what the Privy Council said of them, the option given by the JLSC to the claimant, resigning or facing potential disciplinary proceedings, was ultra vires section 137 of the Constitution, paragraph 46 to 51. Ultra vires mean totally unlawful, clearly unlawful. Next one. That option amounted to unconstitutional coercion and denial to the claimant of a fair opportunity to be heard in breach of the rules of natural justice, paragraph 52 to 57 of the judgment of the Privy Council. Next one. The Commission thereby circumvented the exclusive constitutional process for removing a judge, thereby undermining judicial independence, paragraphs 37 to 45. The actions of the JLC constituted a denial of the protection of the law, violating the Constitution in section 4B of the Constitution, paragraphs 38 to 45. As a result, the claimant's purported resignation was null and void and of no effect, and she remains lawfully entitled to her judicial office, paragraph 58. You would see from my statement today that the evidence which was filed in the court in support of the claim of the claimant included evidence that the claimant was threatened and forced to resign by signing a pre-prepared media release announcing her resignation as a judge. In other words, before the claimant met the Chief Justice on the 27th of April 2017, at which she first knew that earlier that day the JLSC had made the decision which led to her removal, there was already prepared at the office of the Chief Justice a media release to announce the resignation of the judge. I'm going to give you a copy of that letter, and I'm going to give you a copy of the media release today. That is the reason that it has been stated in the judgments of the courts that her resignation was a fait accompli. Even worse, the contents of the media release were false. The JLSC would have known when that media release was issued to the public that the public was being fed with misinformation as to the circumstances surrounding the resignation of the judge. Since 2017, I have not heard the JLSC said anything. At the same time, on the 27th of April 2017, when that media release of the claimant was issued, a media release was issued by Mrs. Carter Fisher, Court Protocol and Information Manager of the Court Protocol and Information Unit, with a release headed Chief Justice Response to Former Judge's Press Statement. The contents of that media release were also false. I'm going to give you a copy of each. The JLSC must have known on the 27th of April that the contents of these two media releases were false and that the members of the public were being misled with misinformation surrounding the circumstances in which this judge signed a letter of resignation. Now, we are talking about a judge of the Supreme Court that the JLSC did this to. A judge of the Supreme Court. Judges of the Supreme Court are guardians of the Constitution, guardians of the rights of the people. The public depends upon judges to safeguard their rights and to enforce their rights. Members of the legal profession, all lawyers, have a duty to stand up to protect the independence of judges so that judges can be fearless in the discharge of their duties to protect the public interest. It has been an honor for me, and I'm sure of my team, to be able to stand up with members of my legal team to fight for the independence of judges and the security of their tenure. The Constitution guarantees the independence of the judiciary because it is recognized that the independence of the judiciary is essential to have impartial justice in our country. And the independence of the judiciary is one of the cornerstones of democracy and the rule of law. The rule of law requires independent courts to resolve disputes competently, independently, and impartially. Those guarantees can only be effected if judges are independent and they enjoy security of tenure. Their independence and security of tenure creates a barrier against any improper influences or pressures, either within the judiciary or outside of the judiciary, for whatever reason, to prevent them from delivering pure justice. It is said that judicial independence is not only the right of the individual judges, but also the constitutional right of every citizen to have an independent judiciary. The Universal Declaration of Human Rights states in Article 10 that everyone is entitled to full equality to a fair and public hearing by an independent and impartial tribunal. The Constitution of Trinidad and Tobago makes it clear that the judiciary of Trinidad and Tobago has omnipotent powers to declare any action of the state illegal, whether it is the judicial arm of the state, the executive arm of the state, or the legislative arm of the state. The courts in Trinidad and Tobago can even declare the violation of the Constitution by a judge in giving a judgment. The High Court and the Court of Appeal also have the power to determine whether any public body, tribunal, public authority exercised in a public function does anything which is illegal, unreasonable, or procedurally unfair. So one sees that the judiciary has omnipotent powers to protect the rights of individuals in Trinidad and Tobago. This highlights the importance for judges to be free and not to be intimidated, and not to fear forced resignations to be effected against them, and to be able to act fearlessly in the discharge of their judicial duties. I have applied these established principles to protect the independence of the judiciary and the security of tenure of judges and the rule of law, what is stated in the Constitution of Trinidad and Tobago, what is stated in the Universal Declaration of Human Rights, and the Bangalore Principles of Judicial Conduct established in 2002. I have applied all those principles to the facts of this case, the unlawful removal by the jealousy of the claimant as a judge. And I could come to no other conclusion that this constituted a serious violation of these principles. This is not an ordinary case. This is not something we can sweep under the carpet. This is not something that we can remain silent for a few days and it should go away. This is a case in which people took an oath. Not only judges, other persons involved in this decision took an oath to uphold the Constitution and the law of Trinidad and Tobago. I have been in public office. I took an oath to uphold the Constitution and the law. And I cannot understand, for the life of me, I cannot understand that how can someone take an oath to uphold the Constitution of the law and something like this can happen and they can remain silent, or they can remain in office, or they can continue as if nothing happened. I cannot understand that. The contents of the findings of the Court of Appeal, which findings were approved by the Privy Council, demonstrate the extent of the illegality committed by the JLSC to remove the claimant as a judge. And what I want to do with this, I want to read it slowly. The decisions that the Court of Appeal made were agreed to by the Privy Council. And the Privy Council put that, I think, in paragraph 1 of its decision, what the Court of Appeal decided in this case. And let me read slowly to you what the Court of Appeal decided in this case so that you could understand, even from the contents of those decisions, the seriousness of this matter. First, the decision of the JLSC of the 27th of April 2017 that Justice A. Caesar be given the option of resigning from the High Court and returning to the magistracy to discharge her professional responsibilities, and that if she refused to withdraw from the High Court, the JLSC would consider instituting disciplinary action against her in accordance with Section 137 of the Constitution. That decision of the JLSC was ultra vires Section 137 of the Constitution. It was null and void and of no effect. This is the Privy Council and the Court of Appeal telling the JLSC what you did, there was no basis in law for what you did. You didn't act on law. You act on something else. You probably act on the whims and fancies of individuals. But law didn't play any part in your decision. What is the second decision? The decision of the JLSC on the said date and the communications of the JLSC of its decision to Justice A. Caesar constituted illegal conduct by the JLSC, because by that decision, the JLSC intended to threaten, coerce, and pressure the judge to resign from office. And that decision of the JLSC was contrary to the powers given to the JLSC under Section 137 of the Constitution. The court held that the JLSC, by coercing and pressurizing the judge into resigning office as a judge, was a form of removal of her as a judge, which was not permitted by the Constitution. You don't need a senior counsel to tell you this. You don't even need a junior lawyer to tell you this. And every individual in Trinidad could understand what this decision is. This decision is saying that the JLSC did not act with law to remove the judge. There was no law which authorized the JLSC to do what it did. The next decision, Justice A. Caesar continues to hold the office of Judge of the Supreme Court because her purported letter of resignation, which she signed, was procured by illegal conduct of the JLSC, and it was null and void of no effect. That again, that is exactly what it's saying. The JLSC act without any law to support it. Next one, the Court of Appeal decided that the JLSC, by removing Justice A. Caesar from office, otherwise than in accordance with Section 137 of the Constitution, denied her the protection of the law contrary to Section 4B of the Constitution and the right to a fair hearing as guaranteed in Section 5(2)(e) of the Constitution. If any one of you here or any one of you occupy a public office and you did what the JLSC did in respect of your office where there was a law and you didn't act as a law, you were out of a job. The Court of Appeal also ordered that compensation be assessed by a judge of the High Court for the breach of Justice A. Caesar's rights under Section 4B of the Constitution. But let me give you an idea what Section 137 of the Constitution says. And you could go home, we pick it up, we can read it. It is fair and unambiguous. A child in Form 1 school in a primary college or presentation college or any secondary school will understand what Section 137 said. Section 137 of the Constitution entrenches the security of tenure of judges. It provides that a judge could only be removed from office on grounds of inability to perform the function of a judge or for misbehavior in office as a judge. Section 137 provides an exclusive procedure which has to be followed by the JLSC to remove a judge. The exclusive procedure required the JLSC in case of a judge other than the Chief Justice to represent to the President that the question of removing a judge ought to be investigated. When the JLSC so recommends, the President shall refer the question, then the President appoints a tribunal to inquire into the matter and to report on the facts to the President and recommend to the President whether or not the President should refer the question of removal of the judge to the Privy Council. So what happened, there's a process, there's a representation, the President makes an appointment, there's a tribunal to be appointed. If when the representation is made, there is no basis to go further, that's the end of the matter. And I will explain that to you because the Privy Council explained that very well. I want, and this probably is the first time you could probably be hearing what was the evidence of the claimant before the court. I'm giving you a summary of that evidence. And that evidence was supported by contemporaneous documentary evidence. In other words, you would see that even while she was being threatened and etc., and she was emotional, she was texting her husband, a priest, and other persons. And that played a very important part in order to support a case, because the law is that where facts in a case is supported by contemporaneous documentary evidence, a judge cannot justifiably ignore those facts. Because the contemporaneous documentary evidence would corroborate what the oral evidence of the person did. Now, the claimant was admitted to practice as an attorney at law in 1986. She was appointed a magistrate in 1992, appointed chief magistrate in 2010. She was sworn in as a judge on the 12th of April 2017. On the 10th of April, that is 2 days before she was sworn in, the Chief Justice telephoned her and inquired whether she had any part-heard matters. She went to the note-taking unit of the Port of Spain Magistrates Court, which was a unit responsible for keeping these records, to give to the claimant records from the court, and that record showed that she had 23 part-heard matters. She informed the Chief Justice the same day or the following day that she had 23 part-heard matters. So before she was sworn in as a judge, the Chief Justice knew that she had 23 part-heard matters. It was open to the Chief Justice as head of the Judicial and Legal Service Commission and as Chief Justice of Trinidad and Tobago to postpone the swearing in of the judge until she was given time to complete her part-heard matters. On the contrary, the Chief Justice permitted the claimant to be sworn in as a judge, and at the swearing ceremony made a speech praising for the appointment. The Chief Justice invited her to a meeting on the 25th of April 2017 to discuss the outstanding part-heard matters and to try to find a solution for those matters. That meeting continued on the 26th of April 2017, and the Chief Justice told her, well, we'll have further discussion how to solve this problem tomorrow afternoon, the 27th of April, I think at 3:30 p.m., around that time. So on the 27th of April, she sat in the San Fernando High Court as a judge. She went to the church and she prayed, according to her affidavit. She saw a priest, and she went to the Chief Justice, armed with authorities, to show the Chief Justice that most of the part-heard matters are what is called preliminary inquiries. And the law was in decided cases that you don't have to have that matter reheard by another magistrate from the beginning. The depositions, that is the evidence taken, which are signed, can be used and it could be continued, the hearing could continue. So she went there armed to show him that. But what happened? Two important things happened on the morning of the 27th of April. Two important things which seem to have had bearing on what the Chief Justice did on the morning of the 27th of April. The first important thing was on the previous day, there was a fracas with prisoners at the Magistrates Court in Port-of-Spain. And the accused persons protested that their parted matters before the claimant were being postponed. And this was on the newspaper. Fracas, Port-of-Spain Magistrates Court. And the Chief Justice on that morning of the 27th of April called an emergency meeting of the Judicial and Legal Service Commission. Now he's chairman of the commission to discuss the issue of the parted matters left behind by the judge. The judge was not invited at that meeting, was not told of the meeting, was not given an opportunity to answer anything at that meeting. And the jealousy in her absence decided that the appellant is to be given the option of withdrawing from the High Court, that means from resigning from the High Court bench, and returning to the magistracy to discharge her professional responsibilities. In the event she refuses to withdraw, the jealousy would consider instituting disciplinary action in accordance with Section 137 of the Constitution of Trinidad. Well, I want to tell you what transpired at the meeting now. Now she is going to meet the Chief Justice to give him this authority based on the postponement of the day meeting before. She doesn't know about this meeting by the jealousy. So when she went to meet the Chief Justice informed her that the jealousy had met an emergency meeting earlier that day and decided that she should return to the magistracy to complete her party's matter, and that she either tender her resignation as a judge or the jealousy would advise the president to revoke her appointment as a High Court judge. Now, she wasn't given any opportunity to consult a lawyer to know what the allegations were. So she was confronted with this. So obviously, she was distraught when she heard that. And she said she was horrified that the jealousy could make such a decision for her to return to the magistracy, and that if she did not return, her appointment as a judge would end. But that is not all what the Chief Justice told her. And this is undisputed. The Chief Justice told her, but it's undisputed in one point, and I'll tell you. The Chief Justice told her that he was under pressure from the President, and that an appointment had already been sought with the President for her to deliver a letter of resignation to the President. He told her that a media statement announcing her resignation was already prepared by his office for her to sign, and that a separate media statement would also be released by him. So imagine you have a job and you're going to your boss, and your boss calls you in and says, listen, I don't care what you're doing now. I have a resignation letter here. That either you sign this or you lose your job. That's exactly what happened here. He told her that the Law Association will also be issuing a media release supporting her resignation. He told her that she had chosen the best course in the circumstances, and the Law Association will ask its members to lend support to her decision. The Chief Justice then left the meeting and went to an inner room to take a call. An important call, to take a call. And in his absence, Ms. Shirley Pear, Administrative Secretary to the Chief Justice, came to her side and tried to console her and told her certain things. The Chief Justice then returned to the room and in the presence of Ms. Pear told her that she just received a telephone call from the President. That's the President of the country, not the President of the Law Association or the President of the Southern Assembly of Lawyers, from the President of the country, who was expecting her by 5:30 p.m. for the purpose of receiving her resignation. When that judge left her home that morning, she didn't tell anybody she's going to resign at 5:30 p.m. She didn't tell anybody that a media release, she's going to sign a letter of resignation was prepared for her. So she was first confronted with this in the afternoon of the 27th of April at about 3 o'clock. When she and Ms. Spear entered the office, they were joined by the Registrar of the Supreme Court, Ms. Jade Rodriguez. Ms. Spear then prepared a resignation letter based on the instructions of the Chief Justice and provided her with a media release under her name, which was already prepared. She stated that she had no role in the preparation and composition of either the letter of resignation or the media release, but she signed the resignation letter and the media release. She stated that she was distraught and felt that she had no choice but to sign both documents, since it was clear to her that her resignation was already orchestrated and that it was a done deal. She stated that while in Ms. Spear's office, she was extremely upset and sometime later recognized the Chief Justice's personal assistant handing the judiciary's media release to Ms. Spear. Ms. Spear then passed it to her, and she then passed it to Ms. Rodriguez. She stated that while she was in Ms. Spear's office, she called her husband, Matthew Caesar. He could not recognize her voice, and she told him that she had to resign because if she did not, the JLSC would advise the president to revoke her appointment as a judge. Her husband told her she should not resign, but she told him he did not understand she was being forced to resign. During the period she was in Ms. Spear's office, she sent WhatsApp messages to her priest, Father Godfrey Stout, a friend, Sharon Raphael, and another friend whose name she did not want to disclose, so as not to breach his confidence. She told them that she was going to President's house. She was asked to resign, otherwise the JLSC would recommend to the President that her appointment be revoked. Those WhatsApp messages were exhibited and formed part of the evidence which was before the court. Matthew Caesar gave an affidavit and was prepared to be cross-examined. The JLC did not cross-examine him. Father Godfrey Stout gave an affidavit, was prepared to be cross-examined. He was not cross-examined. Magistrate Sharon Raphael gave an affidavit supporting that, prepared to be cross-examined, and he was not cross-examined. The claimant stated that she did not have the benefit of legal advice before she signed a letter of resignation and was not given any option for legal advice, to get legal advice. She stated that Ms. Spear placed the original resignation letter in an envelope to be given to the President, and Ms. Spear gave the personal assistant to the Chief Justice a copy of the resignation letter with a copy of the media release of the judiciary, and the media release, which was pre-prepared under her name, for her to take everything to Ms. Carter Fisher, who was an employee at the Office of the Chief Justice. She stated that she left the Hall of Justice at about 5:10 p.m. to attend the President's house for the purpose of submitting the resignation letter to the President. She called her husband, who agreed to meet her at President's house. She was taken to the President's house by a security detail. She was very upset and very emotional, and stated on her arrival at President's house, she and her husband were ushered in to meet the President. The Chief Justice was already in the room. She was very emotional, and the President told her he was sorry the way things had turned out. Her husband asked the Chief Justice, in the presence of the President, why she had to resign, and the Chief Justice told him that the JLC felt as though they had been misled, because she had said she had 28 parted matters, and it subsequently found out that there was 52, and the JLC questioned her case management ability. She then stated to the Chief Justice that she did not deliberately or intentionally mislead him or the jailers. She then took out a resignation letter, which was given to her by Ms. Spear, and as requested by Ms. Spear, she handed it to the President. She was very emotional, and the President told her she should not do anything stupid like committing suicide, and told her that he had a friend from St. Lucia who was at Cavell campus who had committed suicide, and that he, the president, never came to terms with that. The president told her that she had her children to think of, and he hugged her, and she and her husband then left. She told her husband that she could not face a security detail and requested him to send them away. She was then taken home by her husband. She was not given a copy of the resignation letter or the press release which had been prepared for her to sign and which she signed. The two media releases, one issued by the Chief Justice and the other by the judiciary, were both issued by the judiciary on the 27th of April 2017. She stated that the facts contained in the pre-prepared media release which she signed were not true, but she was under pressure to sign the media release and the letter of resignation. The media release was issued by the judiciary, was signed by Mrs. Alicia Carter Fisher, Chief Protocol Officer of the judiciary. And the other media release, which was pre-prepared, was dated 27th of April, was signed by the claimant. Copies of this will be given to you, and I'll read some of this to you. Let me just tell you some of the things what was stated in the WhatsApp messages that was sent by the claimant that day. The WhatsApp message sent to Father Godfrey Stout was going to President's house, was asked to resign. The magistrate Sharon Raphael, CJ asked me to resign. The third unnamed friend, going to President's house, was asked to resign by the CJ, or else they're going to advise the President. So all this evidence supported a case that she was forced to resign because the jealousy was denying that she was forced to resign. Now, the press statement of Marseille Caesar, which was pre-prepared, which she did not prepare, but which she had to sign, states as follows. Dated the 27th of April 2017. I acknowledge the concerns raised with respect to the various matters which were not completed before me as Chief Magistrate by the time of my appointment to the bench of the Supreme Court of Justice, and recognize the effect that failure to complete these matters will invariably have on the stakeholders in the criminal justice system, including accused persons, victims of crime, members of the legal profession. Upon mature reflection, I am of the considered view that it would have been preferable that I advise the Judicial and Legal Service Commission of the full state of my list and request further time to bring matters to the completion before confirming my readiness to assume duties as a judge of the Supreme Court. After careful deliberation, prayer and consultation with my family, I sought an audience with the Honorable Chief Justice, Sir Justice Ivor Archie. Thereafter, I delivered my letter of resignation as a judge of the Supreme Court to His Excellency President Kamona. I continue to regret the effect which my actions have caused on the very person whom I strive to serve, and thank His Excellency President and the Honorable Sir. This was false, as we all know, from the evidence. But this is the information which was sent to the public, for the public to think what were the circumstances surrounding the resignation of the judge, putting all the blame on her. On the same day, the Chief Justice issued a press release to respond to her press release. And it is headed, Chief Justice Responds to Former Judge's Press Statement. The Honorable Chief Justice notes that while Mrs. A.S. Caesar was selected for elevation to the High Court bench following a robust selection process by the Judicial and Legal Service Commission, she failed to manage the transition from the magistracy to the High Court in a way which ensured that undue hardship was not placed on stakeholders. His Lordship also notes that Mrs. A.S. Caesar departed from established practice whereby successful candidates ensure they have fulfilled all outstanding professional obligations before advising the Commission of their availability for appointment to the High Court. The Chief Justice and the JLSC were not made aware of the full extent of the obligation before the lower court, before His Excellency fixed the date for the swearing in of Mrs. Caesar. Well, you all know how that date was fixed. From the facts now, it was not fixed by her request. The Chief Justice is, however, fortified in Mrs. A. Caesar's renewed commitment to place her duty and responsibility to the administration of justice ahead of personal interest, and has noted her willingness to attend to these matters which were pending before her in the magistrate court. Given Mrs. Caesar's commitment to address outstanding matters and have regard to the hardships likely to be experienced by accused persons, witnesses, and the legal fraternity, should matters be started, the JLSC has met and agreed to restore Mrs. Caesar to the magisterial bench. According to this release, the JLSC decided to restore her to the bench even without her agreeing. His Lordship now urges members of the legal profession and other stakeholders in the criminal justice system to continue to render the support needed to ensure efficient disposition of matters in the criminal justice system. That contained false statements about the resignation of the claimant given to the public. I will give you a copy of the resignation letter so that you will see it said, I hereby tender my resignation, etc., etc. The claimant tried to get the president of the country to intervene. Now I'll give you a copy of that letter and the reply of the president. The claimant, by letter dated the 19th of May 2017, wrote to the then president, His Excellency Mr. Anthony Carmona, seeking his intervention in respect of a forced resignation as a judge. In the opening paragraph of that letter, the claimant stated, "It is with deep sense of regret and personal disquiet that the time has come for me to place on record the circumstances in which I was made to tender my resignation to Your Excellency as a puisne judge of the High Court. I also wish to respond to allegations made against me in public, statements made by the Chief Justice and by the JLSC. I'm sending a copy of this letter to the Chief Justice and the Judicial and Legal Service Commission." In that letter, the claimant documented in detail in 7 pages what's transpired at the meeting with the Chief Justice and the other relevant facts, and ended that letter by stating, "Accordingly, I do respectfully ask you to consider these matters and respond to me as a matter of urgency. I ask you to acknowledge that my removal from office was unlawful and unconstitutional and can have no legal effect." The President replied by letter dated the 14th of June 2017, and he said, "I am advised by Queen's Counsel that it would be inappropriate and outside of my constitutional remit to comment on your letter dated the 19th of May 2017, and or to accede to your request contained therein, and in particular your request that I acknowledge that your removal from office was unlawful, unconstitutional, and have no legal effect. Respectfully, Anthony Thomas Finance, Carmona." Before I go to the Privy Council decision, I just want to refer to some of the things what the Court of Appeal said. I won't go through the judgment. I'll give you passages on what they said. Mendonça, Justice of Appeal, at paragraph 41 of his judgment, said the WhatsApp messages were sent by the appellant to a priest, a friend, and an unnamed friend who wished to remain anonymous. There is no dispute that these messages were in fact sent to these persons, whom the trial judge referred to as the appellant's confidants, and I will do the same. The messages were sent on the 27th of April after the appellant had met with the Chief Justice and while she was in the office of Ms. Peer, before proceeding to the President's house to tender her resignation. Mendonça, Justice of Appeal, in paragraph 44 of the judgment, stated that the evidence of the appellant's husband and the WhatsApp messages supported the case of the judge that at the time of her resignation, she was acting under threat or pressure that caused her to resign. At paragraph 84 of his judgment, stated, when according to the chief, and I'm quoting, when according to the Chief Justice, the appellant made it clear by a nod of her head that she would resign. She was then told that a media statement announcing her resignation was already prepared for her. This is the evidence of Ms. Peer, who the trial judge viewed as a truthful witness, and there was no logical reason to assume that the Chief Justice did not so advise. Now, Ms. Peer had given an affidavit, but she did not say in that affidavit that the statement was pre-prepared and that what the Chief Justice said, it was already prepared. That came out in cross-examination. When I cross-examined her, that came out. And the Chief Justice was cross-examined before she was cross-examined. And when I asked her, well, why it is you don't have it, she said, I gave a full statement to the lawyers, but I had to sign it. I signed the affidavit that was prepared for me. So she was honest. She was saying that, listen, I am telling you the truth. But in the affidavit, I did more than that. But that is the affidavit that was prepared by the lawyer. So that is why I congratulate her, because she told the truth and she was prepared to talk the truth as against the Chief Justice. The effect of this evidence is that Ms. Peer corroborated the evidence of the judge that the Chief Justice told the judge that a media statement announcing her resignation was already prepared for her at a meeting with the Chief Justice. At paragraph 86, Justice of Appeal Mendonça said, in my judgment, the decision taken by the JLSC at the meeting on the 27th of April 2020 were to communicate to the appellant a threat that as a means of procuring her resignation, that if she did not resign, it was highly probable or a distinct probability that it would represent to the President that the question of removing her from office be investigated, since the threshold for doing so had been reached. The JLC therefore sought to and did obtain the removal of the appellant as a judge of the High Court by means other than provision of Section 137 of the Constitution. Thus, the JLC deprived the appellant of the protection of the law to which she was entitled to, follows that the decision of the JLC should be set aside, and so to the appellant's letter of resignation. The Court of Appeal of this country, tribute should be paid for them, because here is a Court of Appeal in a very difficult task, reviewing decisions made in part by the Chief Justice of the country. And they had to decide this according to the law, according to their judicial consciences. And they did that with honor. And the country should be grateful for that, because in many countries, that wouldn't happen. Justice of Appeal Barrow at paragraph 109 held, Ms. Peer typed a letter of resignation in the appellant's presence and handed a copy of the same together with a copy of the press release she had received earlier in the day from the court protocol and information manager to both the appellant and Ms. Rodriguez to read. At paragraphs 180 and 181 of the judgment, Justice of Appeal Barrow stated as follows. As I have stated at paragraph 157 and 158, the threat of initiation of Section 137 proceeding is by itself sufficient to pressure a judge into resignation. The communication of that illegal decision to the judge was enough to render the appellant's resignation null and void. But there is also clear evidence of the pressure being put in to Marcia A. Caesar, judge, to resign her position and its effect on her. This occurred during the same meeting of the 27th of April with the Chief Justice when he communicated the Commission's illegal decisions to her. End of quote. Barrow J.A. at paragraph 181 found that the pre-prepared press release, among other things, was clear evidence of pressure being put on the judge, on the claimant, including, he stated at paragraph 181, the decision to immediately visit the President so that she could tender her resignation in person on the same day was unnecessary. Then he said later on, the press release, which he purportedly issued on the 27th of April, announcing her resignation, had been prepared in advance of a meeting with the Chief Justice. She had very little input in her own press release. Both press releases were largely untrue representations designed to assuage public outrage by putting blame exclusively on Caesar and to absolve the commission. What the press releases demonstrate is that a person whose will had been overborne by threat and pressure being manipulated into making admissions she would not ordinarily have made. Those are the words of the judge. That is a local court of appeal, which judgment was endorsed by the Privy Council. Let me quickly try to explain the Privy Council judgment to you. The Privy Council construed and interpreted Section 137 of the Constitution, and at the same time, the Privy Council repeated what I read to you, what the Court of Appeal decided, that the 4 points or the 5 points of illegality. The Court of Appeal held against the JLSC finding that the information which it had before it in respect of the parted matters triggered Section 1371 for it to have a disciplinary inquiry against the claimant. So the JLSC was saying because of all these parted matters, they were justified in making a disciplinary claim. It was also advanced on behalf of the claimant that since the issue of the parted matters occurred before the claimant became adult, Section 137 did not apply. The Privy Council held that conduct even before a person is appointed a judge, Section 137 can apply if it can have impact on the capacity of the judge to perform a business, and held that it could have applied in this case. The Privy Council, however, held that the JLSC could not rely on the evidence which it had before it to contend that it had sufficient evidence for the JLSC to trigger Section 137 for a disciplinary inquiry against the claimant. At paragraphs 37 to 38, the Privy Council held that based on well-established principles of law, including a previous decision from Trinidad and Tobago of the Privy Council in recent claim, before it made a representation to the President, the JLSC had to give the claimant the opportunity to answer the allegation against her and even see what material the JLSC was relying on for that decision to be made. In this case, you would remember the JLSC made a decision unknown to the claimant, so the claimant was never involved in that process before the JLSC. The Privy Council therefore held that the JLSC denied the claimant the protection of the law, and thus that its finding that the information before it triggered the threshold for disciplinary inquiry against the claimant was unlawful by reason of the breach of the rules of procedural fairness. So the Privy Council even knocked down what the JLSC was saying, that it had a threshold that they could have had an inquiry. At paragraph, the Privy Council went further, and you could read it. At paragraph 39 of the Privy Council judgment, in an entire paragraph, the Privy Council showed that if the JLSC had asked the claimant to give responses in accordance with the rules of natural justice, what the claimant could have said to show that there was no basis for a disciplinary charge. So the Privy Council was in effect saying that even if the JLSC had come this way and they had the threshold and they had practiced the rules of natural justice, what the claimant could have answered would be able to demolish their submission. So the Privy Council at paragraph 45 concluded in agreement with the Court of Appeal that the JLSC's decision that the information before it triggered and met the threshold for disciplinary inquiry was unlawful and in breach of the rules of procedural fairness. In effect, the Privy Council was saying there was no basis on the evidence, on the facts, and on the procedure of following the procedure of natural justice for the JLSC to go forward. The JLSC relied on its decision that the information before it triggered and met the threshold for disciplinary inquiry, that is to represent to the President that the question of removing the judge ought to be investigated. The Privy Council at paragraph 46 of the judgment stated that the Commission decided, 1, Mrs. Air Cedar be given the option of withdrawing from the High Court bench and returning to the magistracy to discharge her professional responsibilities. And 2, in the event she refuses to withdraw, the Commission would consider instituting disciplinary action in accordance with Section 137 of the Constitution of Trinidad and Tobago. At paragraph 47, the Privy Council then referred to the decision of the Privy Council in recent Creed and held at paragraph 48 that pressuring a judge to resign by holding out the threat of disciplinary proceeding, as the Commission did, circumvented the constitutional safeguards laid down in Section 137, and that undermined their purpose. The purpose of Section 137. At paragraph 51, the Privy Council agreed with the Court of Appeal that the JLSC's decision that the claimant should be given the option of withdrawing from the High Court bench and returning to the magistracy was inconsistent with the scheme laid down by Section 137 and was therefore unlawful. At paragraph 52, the Privy Council stated that the Chief Justice had a meeting with the claimant shortly after the JLSC had met, at which he told her that the JLSC considered the matter in question sufficiently serious to trigger a disciplinary inquiry, but it made no decision in that regard. It decided, however, that she should be given the option of withdrawing from the High Court bench and returning to the magistracy to complete her part of the matter. The meeting concluded with the claimant agreeing to resign from office and submitted her resignation to the President later the same day. The Privy Council held at paragraph 53 that what the Chief Justice told the claimant placed her under pressure to resign as the implicit alternative of a disciplinary inquiry effectively is the equivalent of impeachment proceeding, as was described by the Privy Council in the case from Trinidad and Tobago recent period. The Privy Council held that would be damaging to her professional and personal reputation and to her standing among her colleagues. The Privy Council stated that it was unsurprising that she responded by agreeing to resign, and then the Privy Council held at paragraph 57 that in agreement with the Court of Appeal that the Commission brought about the claimant's resignation. At paragraph 58, the Privy Council made it clear that notwithstanding that it disagreed with the decision of 2 members of the Court of Appeal on one issue, and that is the issue which the Privy Council showed that there was a breach of the rules of natural justice and it was unlawful, and which the Privy Council, I said at paragraph 39, showed that even if they had asked those questions, there would have been an answer by the claimant. Notwithstanding that, the Privy Council said that notwithstanding that disagreement with that one point, did not place in question any aspect of the order made by the Court of Appeal. The Privy Council said that in relation to the other issues raised in the appeal, the Privy Council stated expressly that it agreed with the Court of Appeal for the reasons given in the judgment of the Court of Appeal. The Privy Council concluded that the declarations as to unlawfulness of the Commission's conduct should stand and dismiss the appeal. My office would give you a copy of all the documents that I mentioned, and I know that we have limited time, but I will give Mr. Vicessa a few minutes before I ask questions. You wanted to say anything? No, I think I'm okay. So, anybody want to say anything? These are the members of the team. Without these persons, I could not do this job. And I want you to understand that. People normally think that when the senior lawyer appears in court, well, he did everything. But let me tell you something, I didn't do everything. A lot of it was done by them. And therefore, the success of this matter does not only rest with me, but also the team and the London team. Mr. Peter Knox, King's Counsel, who is a member of a door tenant of this chamber, He and a lawyer called Mr. Robert Strand worked very hard with me. I remember on that date that the judge came to see me sometime, I think in May 2020. She sat in that corner there. And I must confess, when I heard what happened, I could not believe I was in Trinidad. And I could not believe that that happened to a judge. And I had known the judge for a long time because she was a lawyer in my office as a young lawyer. And I remember she, with Mr. Gaspar, the DPP, was also a junior in my office, together with Mr. Kangaloo, Mr. Wendell Kangaloo. And she was a very quiet person. And she was strong in her faith in God. And when I spoke to her and she told me what happened, she knew that she made a mistake by going along, but she said she had no alternative. She just, her will, she had lost her will. And she just went along. She was forced to do it. And I want to tell you, I made a resolution to myself that day that we are going to fight this, even if it meant going to the Privy Council. And how many years? Since 27 to now, with the help of the good Lord, she was able to succeed. So thank you very much. If there's any question, I'll put it back.
Based on the Privy Council ruling and the unlawful actions of the PLSC, do you believe the Chief Justice should step down, or that Section 137 be invoked for disciplinary action?
I don't want to make this a personal thing. And I would prefer to see what happens in the next few days. But I think based on what I have said to you today, and if I judge it based on myself, having taken such an oath, I cannot see how anyone in that position can just continue in office as if nothing happened. And I do not enjoy, or I have no pleasure in saying this, but I take my profession very seriously. In 1975, I had the misfortune of being charged for contempt of court. I decided that I had to fight that to the end to preserve the right to the independence of the legal profession. Because lawyers must be fearless, even in talking to judges and to put forward the case to their client. I have always believed, as a lawyer, that the judges have to be independent. There must be security of tenure. When I was a law student and I went in the Inns of Court in England, and those principles came clearly to me. And all I can tell you, I feel very strongly of those principles. And I will fight to the end to ensure that those principles are vindicated. So I hope I'll be able to answer your question. Let's see what happens in the next few days.
Mr. Maraj, we saw, as it was titled in the papers, a one-man protest outside in relation to this issue, Israel can. What are your thoughts on that? Do you think, like you said, you believe strongly that this should not have happened and that security of tenure and that kind of thing? Do you believe more attorneys you think should have,
Well, I think a lot of attorneys feel very strongly about the matter. But as you know, lawyers generally don't like to protest. And Mr. Israel Khan should be congratulated for being very outspoken. And many lawyers do not want to be outspoken. I have never understood how a lawyer could be like that. But not all of us are made up the same way. there may be in the days coming a different kind of protest. But for now, I wanted to ensure that members of the legal profession, members of the public understand what has happened in this case, the importance of it. I wanted the members of the media to understand what is at stake here. I believe that lawyers have a duty to perform public education exercises in order to let people know what their rights are. And so that is what I wanted to do today. I am not saying what can happen, but I'm sure you would know by now that Trinidad and Tobago is a highly litigious country. And sometimes, even if a public officer decides to remain in office and should not remain in office, the way of judicial review has developed. I'm sure some lawyer in Trinidad and Tobago might decide to challenge that in the court. There might be protests in any other form too. So I think for today I've discharged my duty.
You spoke about the prison riot being a possible trigger, and then talking about the CJ receiving and not giving out a call, but receiving a call from the president. Did it come out in the case of a potential political influence in this entire matter? Is that what you?
No, I was not. No, I do not think this has any political flavor at all, even though the president, because if it is quite the inference is that a Chief Justice would discuss a matter like this with the party who matters and the problem in the judiciary with the president of the country. And therefore, a letter of resignation of a judge does not have to be handed in personally to the president. This letter of resignation was handed in personally in the presence of the Chief Justice. So, judges who look at this would obviously draw certain inferences, but I don't think the president. I am of the view, though, that some of the persons who were in public office have a duty to speak out.
You are listening to the Street 919 FM. Stay with us for news, interviews, and commentary that shape our democracy. Street 919 FM, the official station that defends the nation.